Up next is a conversation titled The Good, the Bad, the Ugly. This is one that we've done many times. In several of the iterations, we've had Bob Stoll on the panel, and he's the common thread here today. And he's going to be moderating, and I'm going to try my best not to say a lot, which...
Introduce them.
Oh, I will introduce them. But the last time, so when Andre was here, I said that I was going to let him do the talking, and not say anything. And he looked at me and he said, "We will see." So, but first I'll introduce Bob Stoll, who is going to lead the conversation. And Bob is a good friend, and he is former commissioner of patents. He spent 30 years at the patent office, and now he's partner and co-chair of the IP group at Faegre Drinker.
Faegre.
Okay, Faegre.
I hate the name too.
Faegre
Why
Drinker.
not just Drinker? It'd be more apt.
Yeah, right. It'd be more accurate, more descriptive.
Yeah.
See, it's merely descriptive
I
then,
agree.
I guess, right? For a bunch of patent attorneys to work for Drinker. So Bob is going to lead the conversation. We also have on the panel as well. We have one of my law school classmates, although she's much younger than I am. It's a friend of mine, Kristen Murphy, who is now lead divisional IP counsel at ZF Group, and she's been on some of our webinars in the past, and we're glad to have her here live in person. Thanks for coming, Kristen.
Of course.
From Michigan. And then we also have, from a little bit more locally, we have somebody coming to us from Black & Decker. We have Scott Marco, who's senior patent counsel at Stanley Black & Decker, Inc., and they're a very local company, or over in Maryland. So thanks for coming over.
Absolutely.
You know, and I will tell you, I have tried to get people from Black & Decker to come, and I'm so glad that you're here and joining us, because I think you have some great products, and it's always nice to invite people who you use their products. So thanks for coming, Scott. And last but not least is Timothy Garthwall.
Grathwall.
Okay, how did you say?
Grathwall.
Grathwall.
Yep.
And and I should have asked how to pronounce the name. It's Tim. Tim.
Tim
and
is fine.
Tim is a principal at Schwegman, and we're glad to have you here as well. And what I would also like to do, and I will ask the first question to get everybody going. What I've asked everybody to do is during and some have done it actually, most have not, but if you could also fill in a little bit more detail about your background, even your technical background, since we're going to be talking about patent prosecution and that sort of thing. It gives us a little bit of an idea to know from which lane your observations come from. But the first question, open-ended, Bob, I'll have you answer it too. When you hear the topic good, bad, and ugly as it pertains to patent prosecution, what comes to mind? What's the first thing you want the audience to think about?
That, in fact, prosecution can be reasonable. That all we hear about are the problems that occur during prosecution, and there are some bad examiners and there are some ugly examiners, but I actually think that most of them are good, and I really think that it's a great place to work and it does a great job, and every once in a while you get into some bad apples that are problematic.
Yeah, and hopefully we won't just beat up on examiners with the ugly and bad, because I also think that there's plenty of bad attorney work that goes on. It's a two-way street, I think.
I agree.
But we'll come back to that. But Scott, let's start with you. What do you want the audience to focus in on before we really roll up our sleeves and start talking?
So I would say that prosecution by its nature is just always a little bit ugly or messy. I wouldn't call an examiner ugly, but it's always sort of a messy process. It's like, when you write legislation, it's a little bit messy and you don't really want to see how it's made. And patent attorneys are always in the business of trying to say as little as possible and make as few changes as possible, but sometimes it's necessary, and it always becomes just a little messier than you anticipate it's going to be.
Yeah. Okay, great. That's a good start, and I think it's an accurate description, unfortunately, of prosecution. Kristen, what are your thoughts? I mean, you're new to in-house fairly last few years, so you
Correct.
have sort of your foot isn't so far out of the outside world. But what do you think about when you see
Well,
this?
so what I've always focused on is I was fortunate when I started my career a couple of decades ago.
It wasn't that long ago.
Unfortunately, yes. It was. I got the opportunity to participate in litigation while I was doing prosecution, and as a result, my biggest takeaway is really thinking about everything you say in writing, because later on we're going to fight about it and fight about it and fight about it. What did they mean 8 years ago when they said that the widget is disclosed as element 142 when you look at element 142 and it's not a widget? I mean, it's as simple as that. Sloppy prosecution by whether the examiner or the attorney, and the statements made about that sloppy prosecution, you're going to spend thousands of dollars addressing it in litigation.
Yeah, and maybe something interesting to come back to at some point is why that is. I mean, because I personally think it's a confluence of events, sometimes driven by the client who's just unwilling. You have a very complicated application and they're unwilling to pay enough. So in order to do what you can, the attorneys go quick. And when you go quick, you tend to make mistakes a lot of times. So, and that can be the ugly too. So feel free to throw anybody under the bus. Not me. don't throw me under the bus. But if you want to throw somebody under the bus, Tim, we're going to throw you under the bus. But what is your observation, good, bad, ugly, relating to prosecution?
I think I've thought about a bunch of different things today leading up to this, but after the conversation this morning, I think about a lot of things that were mentioned, which I think of fall under the sort of fundamentals of writing a good case, conceptualizing the invention well, knowing your client's business, the prior art to the extent that you can, having as much contextual knowledge as you can, and then writing a good case. Things like varying the claim scope, writing, means plus function, giving yourself as many options. And then, of course, what we've been talking a lot about, the robustness of the disclosure. And a lot of that comes down to, learning over time this craft. And I think you get better at it over time. But I think a lot of it comes down to like an attention to detail. And that just gets sort of greater and greater and greater. And to the extent that you can encode that in the application initially, I think that serves you really well.
Okay,
and your
good.
client really well.
I think that's a great start. And with that, Bob, I'm going to turn it over to you and let you lead the conversation and ask the questions.
Well, that's great, and I'm happy to do that. I also would like to open it up to the floor, because what we're really talking about is ideas, good ideas to use, good ideas to incorporate into your mechanism of doing things.
And if you want to be on mic, you can. This is a hot mic over there. If you want to ask your question, so the video audience can
That's
see this.
great.
And if you want to remain anonymous and stay in your seat, that's fine too.
I want to start off by saying I don't completely agree with you, Scott. I actually think it's kind of exciting to draft an application. What I try to do, and I don't think it's messy, I try to tell a story. I kind of use the European style, even though it's kind of discredited in the MPEP. But what I try to do is talk about a technical solution to a technological problem and how my invention revolutionizes everything. And I really like explaining the story. What I would like from you guys is, what couple of things do you think is critical in drafting of the application, in putting the application together? I mean, 2 or 3 tips that make for a more readily allowable claims. Let's just go down the line, Scott.
So a colleague of mine really recently used a phrase which I love, and he said, "Claim broadly, disclose specifically." And I think it's important to.
I like that.
Yeah, I want to plaster it to my wall now. I like that because it really goes to the heart of, you need to have a lot of detail in your specification because you never know what you're going to need to pull from it later. And especially if it ends up being like one of these really important patent families where you have multiple continuations, you need to have that fallback subject matter. So while the inventors I work with, they always want to get the broadest claims, and they'll throw out an idea like, can we get a claim to this? I'm like, maybe, but you need to give me the technical details to back that up. So I think it's really important to get as much technical detail up front when you're drafting the application. I was listening to the last panel talking about secondary considerations and unexpected results. To even get that into the specification ahead of time goes a long way towards getting applications allowed. I mean, I work on some applications on, for example, saw blades, and you wouldn't think that there's anything new under the sun about a saw blade, but there actually is, and if you can get some of that story into the specification, you can really get some claims allowed that way.
Yeah, I agree. One of the things that I always have taught when I've worked with younger attorneys and learning to draft, I'm like, we need to do the sales job. Because we're selling to the examiner why this should be allowed, and then ultimately we're going to have to sell to the fact finder of why this invention was so cool that we got a patent and you're entitled to money. So, and how do you do? I spend a lot more time on the background in telling a good story without shooting myself in the foot about like leading to what earlier panelists had say, you don't want to leave yourself open for, wow, the solution's obvious based on this, but really explaining a lot of problems, and I try, if I can, multiple problems. And then on the detailed description, different elements solve different problems. They don't all solve all the problems. We want to make sure there's a varied level of fantasticness in your application, if you will.
Is that a term of art, fantasticness?
Yes, that's my word.
I like that.
I've got a question for you then.
Yes.
Based upon what you said, do you include every type of claim that is disclosed in the specification? And I'm not just talking about what another person said, which was every different, composition, of matter, process, et cetera. I'm talking about things that are restrictable or might be considered restrictable. Do you drop all of those into the claims at the end, or do you leave them in the specification going after one series of claims and file a continuation or a divisional on the other?
I do the latter because and here's why. I mean, for certain cases, if I think I can get away with an apparatus and a method, I'll do it. But generally speaking, it's throwing money away. It literally is throwing money away. I'm like, why would you file more than 20? And just so everyone's clear, I'm a mechanical by my engineering degree, though I do work on electrical cases. I get 20 claims, so that's included. They're free, with my application fee. So I'm going to focus on those 20 claims. And if I really think the other types of claiming strategies are worth it from how am I going to enforce this? Is this something good to have in our portfolio? I have everything set up in my spec to do those. And in my prior life for medical device work, I would do that quite often. I would have these mega, I would call, parent applications where I'd have a whole system described with different components to set up for multiple families, and some of which I filed on the same day of different, one's the system, one's a specific component, one may be an operation type related application. But I made sure all of those were available to quickly build a patent portfolio because that client needed that. But the reality is that investment in the spec at that time paid off tenfold in the growth of their portfolio with very simple claim amendments later on.
Jim?
Yeah, interesting. I agree with my fellow panelists. I guess what I'll add to it is over time I seem to spend more time in the claims, actually less probably total time, but I write a lot of claims. So for a given case, a day-to-day case, I agree with what Kristen was saying, 20 claims, we don't need to go crazy. But I'm always kind of thinking, especially if it's, my client, it's a more important strategic case, but I'm always kind of thinking about different ways I can claim. So different independent claims, multiple device claims that what I call claim the same basic scope, but in different ways. So means plus functions, and you could write a device claim with structure. You could write a device claim. I'm a mechanical guy, so write a device claim with function, means plus function. But I could also write multiple, claims with structure with slightly different approaches, and that may be dictated by the invention, or it may be just sort of trying to conceptualize the invention. And I think that's something that is I'll just add to the discussion is important as well, conceptualizing the invention, knowing what is the invention, what's an appropriate amount of scope I can go for. And lately, I think more and more about this whole breadth issue because it's clearly an issue. And going too far can be, problematic, so.
So you're talking about basically the Amgen issue with respect to the 112?
Yeah, Amgen, as well as I think American Axle's interesting too, because that claim to me looks like it's interesting, right? In the mechanical space, we don't think about 101, we don't run up against it, but American Axle says you're not immune. And in that claim, when you first look at it, when I first look at it, it's like, well, that's interesting. I could see a lot of mechanical practitioners writing a claim like that, so.
Me too.
Yeah.
And with respect to the Amgen case, I'm curious to know whether people are going to eventually file a lot of reissue cases based upon the fact that they can claim specific embodiments that are in the specification.
Right.
And they probably don't have anything still pending at this point. And I think you're going to see some of that in practice. Anybody out there have any ideas of or any models with respect to drafting of the application? Anybody have a unique technique or something they'd share with everybody else about one aspect of drafting a patent application?
Come on.
Wow. Well, go ahead.
All right, I like to see applications that have an appropriate sense of proportionality. That means not too much energy on background, not too much energy on context, but a lot more energy on what we're trying to protect. So for some of Caterpillar's patent applications, describing the machine might take a ton of paragraphs and a ton of the writer's time and attention. And then is there anything left over for the invention that should be there? So again, proportionality is fine.
I think that's a good idea, but I also think that companies should be paying a little bit more for drafting of applications than they currently are. And I actually wrote an article that you published and asked the Patent and Trademark Office to study that because I want that study to reveal that, in fact, if you're paying $5,000 or $6,000 for a complicated application, you aren't getting your money's worth.
Well, in some cases, Bob, it's not even that. They're paying $3,500, and we won't name the letters of that particular company.
It's ridiculous.
But unbelievable.
I saw some other hands back there. Yes, ma'am.
Yeah, one of the things that I will do for some cases, and this goes back to the link between litigation and patent prosecution, is especially for entrepreneurs where it's kind of their main or very important case, is I will encourage them and ask a litigator that I might know to read over, a relatively final draft and find those holes.
That's a great idea, actually. I haven't done that.
Can I interject? That's the whole reason for this panel, because Meredith Addy was on the first couple iterations with you, and she is a litigator, and she said, I wish I could get to the patent owner before they made X mistake, or before they didn't do this, like keep it alive with a continuation or whatever. That's great advice.
Yes, sir, in the back.
So for international cases, the 3 and 20 is just good to keep costs down, and I agree you're throwing away money. But since I'm in the claim writing mode, I draft the claims and tack them on at the end of the specification with letters rather than numbers, because if I get into Europe or I get into China and I want to keep my claim count low, but I need literal support, I have it there for my other type of claims.
It's another.
Absolutely.
Yeah.
And/or, yeah, especially making sure that you can, when you're using those different limitations, that you use and/or also includes, so you can make the different combinations in Europe.
The other thing is I always make all of those lettered claims multiply dependent.
Mm-hmm.
So
Yep.
that they are mix and match
Yep.
every single way you go to prevent anyone from saying, oh, well, you hadn't figured out that particular combination of mixing and matching.
That's
One other thing that I do is if I'm representing an entrepreneurial client and they have not gotten to me in time, I will actually try and include either in the background or more likely in the specification an identification of their own prior art that they have already released on the web before they got to me. And to do that in order to be able to have a better chance of utilizing the AIA exceptions to prior art under 102.
Oh, yeah, good.
yep, another good one. Sir, you had.
All provisionals are filed with multiple dependent claims. I think our record is 647
Whoa.
claims. And it sounds like a lot, but we'll file the PCT with 647 because in China they're $10 a claim. You're talking about $6,500. That's not really.
That's a good suggestion too.
Yeah, and in the PCT, we file one claim that we know is maybe not patentable, because in China and other places, once they're published, you can't take claim limitations out, you can only add to them. So when you get to China, and you have to draft a claim to cover a competitor later, you can add what you need to add and still be okay with the law.
Yes, ma'am.
Kind of before I start drafting, I ask the client, is this going to be an offensive patent or a defensive patent? I know you've been talking about that a lot today. What is the point of your patent? Because if you just want a patent that's hanging on the wall, then I know what to give you. But if you're going to actually be litigating it, that's an entirely different story.
Did you want to say something? Okay. All right, I would like to switch over now. These are really great suggestions. Some I didn't think of, like talk to a litigator before you file the patent application and make sure you plug the holes. I'd like to shift over to prosecution. Give me a couple of tips that you think advances your case to allowance quicker than it normally would have, or in better form than it normally would have, that you use frequently.
So one thing I'll do is actually file in the first application somewhat narrower claims than I think I'm entitled to sort of butter up the examiner, get the examiner to buy in, allow the case pretty quickly, and then come back in a continuation and then broaden out from there, rather than trying to go broad first and then narrow.
Interesting.
I like that strategy.
So do I.
I think it's I think it's brilliant because that's also what I did. But I don't understand why it's so difficult to understand that you can't get huge space in the first go around with an examiner. I mean, examiners, even the good ones that are going to issue patents, don't want to overissue.
Yeah. Any more?
So along the same lines, if you're going after a competitor product, don't be afraid to go super narrow to cover them, because if you can cover their product with a super narrow claim, it's going to be almost impossible for them to invalidate it.
Mm-hmm.
I like that too.
I like to argue at least one dependent claim, usually multiple dependent claim. I think dependent claims in a response and or interview. In part, I'm setting myself up for appeal. We haven't talked a lot about appeals today. I love appeals, but only if I know I'm going to win. But I'm always thinking about that move down the line, because I will often see in an office action, short shrift being given to the dependent claims by the examiner. And it's kind of that buttering up the examiner. As soon as you get one, more is going to follow. So that's always my goal, at least get one claim to be indicated as having allowable subject matter, and then think about different combinations that you can do in a further amendment or a continuation to get further claim scope later on.
So I will do two things, or I'll say two things about this. One is what I call clarifying amendments. I'll look at the claim, and depending on where I am in prosecution, I will see if I can clarify some technical aspects in the claim or some elements and features in the claim where I don't think it's really, it is technically, anytime you add words to the claim, you're narrowing it in a sense, but to me it's not really a narrowing amendment, it's a clarifying amendment, and I think it might get some traction with the examiner. And so I've had success with that, especially when you get sort of like in the after final consideration program is one place, but just generally, I think that can be a way to bring the examiner onto the same side of the table. And then I always go broad. I'm very interested in what Scott said. I've been thinking about that. I think it's an interesting strategy. Clients aren't, in my experience, they want to go broad first and then, narrow if you have to, and also consider maybe differing scopes, but go broad first. I think, so anyways, so that's an interesting strategy. But the other thing I was going to say is obviousness. So I thought it was really interesting what Keith, when he was talking about secondary considerations, what Keith said is don't say the words. So what I end up arguing under obviousness a lot of the time is a form of arguing hindsight, because the examiner almost always does it. There's two things they almost always do. They use hindsight reconstruction, and they don't give you a reason. They make a conclusion, and they put some words next to it, but it's not a reason. And so I attack those two things, and I've had good success with that, but I never say hindsight. Sometimes the examiner comes back and recognizes what I'm doing and says, a little bit of hindsight's okay. And I go back to them and say, the question is not hindsight. The question is you haven't answered the question of why. Why would it have been obvious? And so I'll just throw that out there to add to the obviousness discussion.
That's a great addition. I hammer on interviews. I just gotta, I can't say enough. Drew, I'm still ticked off that you canceled that first action interview pilot program. And don't tell me it wasn't used, because I used it.
One person used it.
Me.
Yeah.
Me. I interview again, and I interview again, and I do it nicely, but first of all, I'm establishing a relationship with the examiner. Secondly, that examiner is likely going to handle other applications from my client because they're inventing in the same area that this application is invented in. So I am getting them to understand me, to like me, to want to help me out, and I cannot tell you how important it is to interview. I think it's very important. It shortens the number of actions to reach a conclusion. I liked it at the beginning because I could instill into the examiner the idea of what I was going after, and so in 20% of the cases, they kind of misconstrued what the thrust of the invention was. I just cannot say enough about interviews. Drew, you wanted to say something.
Yeah, I was going to mention that Scott's idea of filing narrow has a secondary benefit that I've heard people discuss. I don't have personal experience with doing this, but we were talking earlier about classification and making sure you don't write your claims too broadly that they end up somewhere you didn't intend them to be. I've heard people in areas where there's some gray area between respective areas of classification write narrower claims first to make sure it gets to the right area, and then you can broaden it out during prosecution.
Are you kind of venue shopping when you're doing that? Like going for a particular examiner or art unit that might be more receptive to an allowance than others?
Maybe. Making sure it goes to the place, the intended place.
Right.
And you don't have unintended
I think it's a great idea. I do that. Any other ideas? Yes, sir.
I'm a big fan of the going narrow first. And I think it's a good place to use the track one, especially if you're a company that needs to be showing that you're gotten somewhere to investors, licensees, to have a granted patent and then have the opportunity to file broadly in continuations, I found has been incredibly helpful in many situations.
Thank you, I agree.
Yeah, if I can,
Ma'am?
And sometimes with filing the narrow claim, you get the allowance, and while it's still fresh, the reasons for allowance are still fresh in the mind. You might do an RCE and file the broader claims right there at the RCE, and now you don't have two maintenance fees. So now your cost savings to your client is they don't have multiple maintenance fees decisions to make, but now they have an application. Now you broaden it out. Instead of 3 independent claims, now you have more independent claims and less maintenance fees. But use the RCE practice to bring in the broader claims.
Yeah, along the same lines, sometimes what I'll do is to take full advantage of the 3 and 20, is file 1 independent claim with 17 dependents, and then 2 other independent claims of varying scope. If I get them all 3 independent claims allowed, go back to the examiner and say, can I make a 312 amendment? Add a bunch of dependent, so I'm just gonna add the other dependent claims to each of those claim sets. Now I'm only paying dependent claim fees, and then I get the 1 patent with the 1 maintenance fee and the 1 issue fee.
I like the strategy. You had something.
When I've had an interview with, I've done this a number of times, with indication of allowance, I then go back to him and say, are there any other combination of elements that you think would have an indication of allowability? And sometimes when the original claim was like this, but all we're getting is this, we also find out there was this and this. And I've added independent claims and dependent claims and had one.
So that's part of your interview. You ask them about other elements that would be together provide for allowable subject matter.
You know, you have a good collaboration and there's an indication of allowance. They're much more likely to talk other areas that they've seen.
So I have a prosecution tactic that I haven't tried yet, so I need everyone here to tell me if it's acceptable. And that is, I just learned of this, filing continuations with non-publication requests. So the parent issues, becomes part of the public record, acts as prior art against your competitors, but keeping the continuation non-published causes the infringers and competitors to not know what's happening. They can see in the patent center that there is a continuation, but they can't see what the scope of the claims are.
But your original application is issued, correct, or published, which means that the specification is in the public, so they do know what you have the possibility of claiming at any time. Your secondary applications, I guess, to not be published would only be filed in the United States, so you're not filing overseas, and you're losing all of those markets, and I kind of have a problem with that.
But if this is just limited to the U.S., if the client is only filing in the U.S.
Yeah, oh, then it works.
One way to do that is you file your continuation, file with the original claims. Don't do anything. Wait till it publishes, then put a preliminary amendment in. So now that preliminary amendment is going to be harder for people to find. They can find it, I don't care. Right? They're going to be able to find it, but it's not going to be published. You're going to lose the publication, defense, you're going to lose that. But if that's your strategy, that's one way to do it as well. I know for us, when competitors do that to us, our clients are on pins and needles knowing what the claim is going to be. Because they're just frustrated, because they don't know where the claim's going.
Yes, ma'am.
I take a similar approach to Scott, but I try to keep it all in one patent. If it's someone that has a smaller portfolio or maybe only one. Sorry to anyone at the patent office, but the MPEP says the first claim should be the broadest, but it's not a requirement. So my picture claim will be my first claim, and it will be very, very narrow. And I find that it narrows the examiner's mindset. And then my other 2 independent claims, they will have the same patentable nuggets in there, but they will be much shorter. They'll be a really short pencil. And it just finds that I get that really narrow claim and maybe some of the broader claims without having to RCE or do a continuation. Sorry.
I think
It's a should. It's not.
The NPEP is not binding on applicant as long as it's not referring to statute, case law, or rule. So, I mean, and I know Will Covey is over there.
See, that's what I was just going to point out, that Will is in the room, so nobody make
looking to
any.
take away my reg number, but I am telling you, it is not it's not binding on you except for in those circumstances.
If Will comes after you, I'll represent you.
Thank you.
I think you need to rename the panel Psychological War Games.
Right. You say that, but the next time you're on this panel, that's what it will be called.
Yeah. Yes, sir. Brad.
So if you are going to file a con, remember Rule 1.115. You do not want to amend the claims as of the date that you file the con. Because if there is any new
Substitute specification.
you get a new effective filing date, or you will at least have to fight about it, or someone will have to litigate about it. So always wait a day, file the substitute spec and your new claims by way of preliminary amendment.
I think that's good advice. Anybody else on this particular topic? God, you guys are really into these ideas that I think are great. So I want to pivot a little bit, something that Will Covey definitely could comment on, but I want to also talk about how do you see the inventors and the prosecuting attorneys getting into trouble? Where do you find issues, or what keeps you awake at night? What are you worried about dealing with prosecuting the application at the PTO vis-a-vis your obligations under Rule 56, for example?
I'll just start at that end.
Okay, down there, Tim.
Yeah, I guess I would say, well, so Rule 56, I mean, I've seen situations where a client's inventor withheld information. So that's obviously problematic. There's, we can try to guard against that by having systems in place, inquiring with the inventor about all the information that they have available, kind of walking them through that kind of in detail. If you have articles or you think it might be related, let me know. If in the future you remember something you forgot, send it over to us so we can take a look at it. But outside of Rule 56, I see, when I look back at portfolios like in a due diligence, I see things that happen that are formal and are easy sort of things to watch out for, like making sure that the company owns the patents, having a chain of title, not making unforced errors in the specification, using absolutes or disclaiming anything, or in prosecution for that matter.
Not claiming small entity status when you're not small entity?
Small entity status, yeah.
I hear that's a big one lately.
And the other thing that I've seen is companies, not large, sophisticated companies, don't tend to do this because they've got all this kind of nailed down, but medium-sized, even relatively large companies, but not huge companies, will get into and build a portfolio that has patents in it that there might be some inventorship and ownership issues because they had a consultant working on things. There are third parties involved in the patents, and those rights have not been tied up. Well, we have a non-disclosure agreement. Well, it handles IP a little bit. So those are some things that I've seen.
I would say I have a story that I think we talked about before, and I'll tell in a second. But like from the corporation side, now that I'm in-house, I mean, we certainly ask the inventors, like, you need to tell us, you have an obligation to tell us if you know of anything. A lot of the cases that I have been working on recently usually originate in Germany or the UK, and they're pretty good about identifying the prior art, and we usually have search reports as well, so I'm not too worried about there. My story, this is great. This very small company had filed an application, and before it got allowed, they sent a cease and desist letter to my client saying, hey, you're infringing, we're about to get this patent allowed, and we're going to sue you. We're going to put you out of business, so on and so forth. My client's like, well, I don't see how that's going to be possible because we've been making this particular item for at least 12 years. And in fact, here's a sample, and sent them the sample. And to their attorney, who looked at it with his client and then sent it back to my client, did not tell the examiner. didn't write to the examiner, never described it to the examiner, no mention to the examiner. They got their patent, they immediately sued my client and like 3 other people. Several years later, we finally go to trial. And boy, was it fun to watch them get the same garment back in their hands again. Does this look familiar? How about this letter that enclosed this? So it was very fun. And quite frankly, there were differences probably could have argued about, but that didn't matter because the story was they had it in their hands. And the jury loved it. Patent invalid. Unenforceable, actually. So
I can't believe that went to trial.
it was a fun trial.
Yeah. The biggest, being in-house, the biggest challenge in dealing with our inventors, and our inventors are great, is just educating them to know to come to the patent attorneys before they go somewhere else with a disclosure. Sometimes they don't, especially some of the new people, young engineers that are coming in first out of college, and this is their first job, and they don't appreciate the serious consequences that can come from not even a public disclosure, but a disclosure to someone, to a third party, not under an NDA, that can really have serious ramifications for patentability later on. So that's really a challenge.
I agree with what everybody's saying. I personally use a checklist for when I'm about to draft an application for the inventors and for the in-house counsels, explaining what the obligations and duties are, explaining what I need to know, asking who the inventors are, is there any cooperative agreement, are there any other possible inventors. I make sure I get it signed by somebody at the company because I want to show that I've done my due diligence, and I really think it's a good idea to actually have a signed document that I have met my obligations. For example, I deal with a lot of Japanese companies, and a lot of their inventors don't speak English. That means their oath has to be administered in Japanese, and they have to be able to understand it. And there's a lot of little things going on that you need to take care of. My day job is dealing with Rule 56 mostly, and I've probably testified over 70 times, and I've seen all kinds of problems. But what I'm seeing right now mainly are inconsistent statements. Somebody's making a statement to some person about what's the nature of the invention, and they're making a statement to the Patent and Trademark Office that isn't exactly right. I also see advice from the Patent and Trademark Office about if you're going to withhold a document, keep a book and write in that book your reasons for withholding the document. Do not do that. I do not agree with the PTO on that advice. If you're gonna have to write something in a book, submit the document to the Patent and Trademark Office. Just in the abundance of caution, submit the document to the patent. Don't keep a book of what you didn't submit. And mischaracterizing references is another issue that I've seen a lot of problems with lately. I don't know why. It's kind of clear what the reference is saying, and I think they're not doing their due diligence. Any other ideas out there for both inventors and prosecuting attorneys?
Well, isn't keeping a book like that, isn't that what the IRS got Al Capone on, is having separate books? I mean,
Well, it's
why?
a tax evasion.
Did somebody in a case you were involved in do that?
Yes. Yes. And it's recommended in the MPEP.
Well,
I'm
there's
sure
all
Barr knows where it is.
kinds of things that are recommended in the MPEP that we don't want to do.
No. I mean, I think that there's a lot more peril out there for prosecuting attorneys than people realize.
Well, and another thing, like MPEP suggests that you discuss the prior art in the background. Nobody does that. I mean, and it's malpractice to do it.
The Germans do it.
Well, right. Enough said.
Yeah.
No, but there's ways that you can handle that overseas if you're filing here first, where you don't have to contaminate your U.S. case.
I agree.
Yeah, you can mention the art, just don't characterize it, but yeah, that's where you get into trouble.
Yeah.
Any other things that have happened to you or you're aware of or problems that you see. Yes, sir.
Inventors that try to sneak embodiments in after you get to the case, but they're really just future inventions that they will invent more than 1 year after that one publishes. And then, you have this prior art now, that it was just a paragraph that he put in, and he's gonna make another whole disclosure later. But now you have this paragraph that's a real problem.
Ah.
And you just think, oh, it's an embodiment, so they kind of trick you into it. It's not an embodiment, it's his brain thinking about what he's gonna do
Next.
next.
Others? Yes, sir.
We had an issue, U.S. inventor and an inventor from India. And I filed in the U.S. without getting a foreign filing license from India first. And,
You can go to jail for that.
in India, you can.
Yeah.
Thankfully, the inventor goes to jail, not the attorney.
Yes,
Yeah,
luckily.
Yeah.
We ended up
Good point.
we ended up letting the provisional go, just to make sure that everybody.
I've seen people being added as joint inventors who were like running the lab tests. And I mean, I've seen all sorts of strange things. I don't think that there's a broad recognition that it's the individual who conceives of the invention, and the reduction to practice has nothing to do with inventorship. But that concept's still out there, and it's problematic in a lot of the cases that I'm working in. Any other ideas? Will, what have you seen recently? What's coming to the Office of Enrollment and Discipline? I know, but give me one.
I mean, the only thing you said, all excellent suggestions. There's two things, right? There's the patent, and then there's your license. They're two separate things. And sometimes, keeping notes, I have recommended some small amount of notes, because if we come and ask you, because I've seen this happen, we ask you 5 years after the fact, hey, what happened on June 20th, 2023? You're not going to remember.
Right.
And we're not looking for a lot. Which one another you consider that we may disagree with you, it may have turned out horribly wrong, but at least if you thought about it at some point. Those cases you mentioned with the microentity, they're not doing anything, right? And that's the problem. If you do nothing, that's going to be a big problem.
Yep.
If you can't say I did X, especially if you do nothing, and you say, well, I thought about it, I did this, or I did that, it's good if you have something about it.
Well, that would be on my checklist that I
Yeah,
send to the
that's
inventor.
all
So.
you said, great. It's great. There are cases where a lawyer's relying on a non-lawyer or non-agent, and that person's they don't have a license to worry about.
Right.
There's a case out there called Ohio Willowwood that basically dealt specifically with a director of inventions or something. I thought the person was called. Wasn't telling the attorney everything, so guess who's on the hook?
Yep, the attorney.
Yeah, not the other person.
No. No, but that's why I do a detailed checklist. And when I say don't keep a log, I don't keep a log of what I'm not sending in. That's I've never done that. I don't recommend it. But I do recommend a checklist, and a detailed checklist. With everything in it.
I do think that, I did have a situation years ago where a piece of prior art came after we paid the issue fee, but before it issued, it was probably going to issue the next day. And we looked at the prior art. I looked at the prior art and I'm like, oh, this is actually not as good as the reference the examiner cited. I wrote a memo to the file for that, and we put it in our electronic file. In that situation, I'm like, I had a reason.
Yep.
Here it is,
Yep.
and here's where the record is. And and I was very confident in it. Had I not been confident, I would have pulled it. I would have filed something immediately and then put that prior art in
I would
front
have
of-
done what you
yeah.
did in that one particular
Yeah.
instance, just not regularly.
Yes.
I get you. I would do that.
But that situation, I run up against that situation a lot, and you have to review the references. It's kind of a special situation. There might be some cases where it's kind of clear, but I always err on the side of just disclosing the documents.
Right.
It's tough when you have a portfolio for a client where it happens repetitively, and it's tough to get a case allowed because you've got a bunch of cases, you relate all the cases to each other because you want to cross-site all the information appropriately in the U.S., and you run into this situation where you get an allowance and you got new art. You get an allowance, you got new art. And so sometimes you have to go in and say, okay, and make a determination. But
All right, well, we've got less than 5 minutes to go, so I would say any concluding ideas, any thoughts, any?
I have one. All right. So the examiner's reasons for allowance. I see many, many practitioners do not respond to them. Don't do that. I have language in there that just says you don't acquiesce in the examiner's reasons for allowance. Why? Because you don't know what you need to argue in litigation 10 years later after the fact. Leave yourself some room to maneuver later.
I agree with that. I do that. But I also do it in response to the examiner's interview summary form.
Yep, same thing.
And I put in my own summary of what happened, because it's usually, these patent applications were discussed, these references were discussed, and nothing more. And I want all of the issues related to the rejections to have been discussed.
I want it as muddy as possible.
Yeah. I hear you.
I'll just finish up and say what I kind of started out with, which is, and go back to the good versus the bad and the ugly. I think that understanding and bringing to bear technical detail and knowledge about your client's business and who the infringers are, all of that information into the application to write that robust application in the first instance, in excruciating detail with as many sort of flexible options down the line is where it all begins. So,
I totally agree with that.
And I'll say, to follow on that, if you don't have all the technical detail right away, file a provisional, and then file a second provisional, and file a third provisional, and file a fourth provisional until you get to that conversion deadline.
I'm with you. Gene, any comments or questions?
Not really. I mean, I guess the one thing that I would say is we spent a lot of time, I think, talking about the MPP and the rules and this sort of stuff and do that. What I think it's probably a good idea to actually not commit malpractice. And I think I say that and I laugh, but like you also have seen cases, right, where attorneys have done just weird, strange, bad stuff, and we'll talk about some of them tomorrow during the ethics case, and I think that nobody wants somebody else overlooking your shoulder and looking at your files and say, why did you do this? Why did you do this? Why did you do this? And I think one of the things I always try and tell people is the cleanest, best way to make sure nobody's going to overlook your shoulder. Will COVID OED is not going to overlook your shoulder, is to make sure you communicate with your clients, you keep them up to date, and you don't give them a reason to believe you committed malpractice. Because at the edge of an ethics complaint is usually a malpractice complaint. A client got screwed or felt wrong or you ignored them, and then it's like a thread and it just gets pulled. So it's going to sound quirky and kitschy, but just treat people with respect. And I always try and tell people, treat clients like they're your mother, like you would like your mother to be treated. And I think it'll go a long way to staying out of trouble and doing a good job.
I also don't take clients that are problematic, and I mean there are many different
right.
Problems that you can get. If they're not going to pay enough for us to be able to get the benefits out of it, I hand the work back.
And sometimes that's when you are going to commit malpractice, is when you're trying to do somebody a solid and say, well, I can get you something, I can help you, I can do this, I can do that. And that's always 100% of the time a mistake. And the other thing I would say is we've always had around here a rule is the minute you exhibit the crazy gene, you are no longer doing business with us. And I think too many times attorneys, particularly at the beginning of their career or when they first open their own law firm, they forget that because they don't have as many clients and they need this work and it's always 100% of the time, in my experience, a mistake.
I fully agree with you. In fact, I'm very careful about who I pick up in the first place because
you have to be.
And I usually end up getting clients where I'm troubleshooting applications that are already at the Patent and Trademark Office, and I've seen some work that I don't think should have been done, and it's problematic. So sometimes the examiners are at fault. Sometimes the applicants are at fault. I think that if we all try to do the best work we can, we'll have a better product and less problems at the patent.
That's absolutely right. And this is why I love this panel, because if we restarted this panel or did this same panel tomorrow morning, the focus would be not on the MPEP, not on the office, so much on the exam. It would be on clients,
Yeah.
or it would be on this. So there's plenty of good, bad, and ugly out there to go around. And sometimes it's just nice to sit back and say, geez, I'm not making at least that mistake.
Yeah. Right. That's it.
That's it. Thank you, everybody.
Thank you.